Good evening, this is John Milburn for Laws 12063, Advanced Statutory Interpretation and Drafting. We're into week 8, but I am finalising week 7 material, which will take a good half of tonight's session. But I will catch up over the next few weeks. Thank you very much for those of you that have joined us live. I'm very appreciative of that, and I'm very conscious that the first assessment is due on Thursday, the 6th of September, at 11:45 p.m. If you're watching this as a recorded session, please bear in mind that if you wish to make an application for an extension, not that I'm encouraging it, you need to do so before the cut-off date. I won't accept any applications after the cut-off date. If you happen to be late, don't stress, you'll only lose 5% per day for each day of late submission. The usual rules apply. And with me, I'm sure you're aware if you've worked with me in the past, that I do have a cut-off date. That cut-off date is 15 September 2018. That's Saturday evening. All of my assessments are due on a Thursday, cut off the following Saturday. If you fail to submit by the cut-off date, I will award you a nil mark, so there's no room for manoeuvring there. If you submit a draft material, then I will mark it as the final material if it remains in that form as at the date of submission. So at the moment, looking at the material, no one has submitted. I do have one draft, which I'll treat as the final if it remains in that form, as at 11:45 p.m. on Thursday evening. So before I start, are there any questions about the assessment, about the application for extension regime? Hi, Siobhan, for joining us. All good? All right. Well, if there are any questions, please let us know. Your usual rules apply. Please unmute your microphone if you wish to ask a question, or just use the chat facility. Siobhan, do you have any questions? Or no, all good? All right. Thank you. So let's continue with our discussion from last week in relation to, obviously, the most important piece of legislation for this unit, which is the Acts Interpretation Act. We were discussing through to Section 9. We're down to Section 14. As I encouraged you to do on the last occasion, please follow my discussion by looking at the Act. If you're watching this as a recorded session, please do likewise. Let's have a look at Section 14. The Act includes everything which is within the bounds of the Act except footnotes and editor's notes. Importantly, what that means is that examples do form part of the Act, as do headings and subheadings. Section 14A, very familiar to you. Interpretation is such that will best achieve the purpose of the Act, and that is to be preferred to any other form of interpretation. So by now, I'm sure that's all second nature to you. But when you look at Section 14A, bearing in mind what we've just discussed about Section 14, you'll see there's an example. And when I see an example in a piece of legislation, I look at it carefully, and often it's there because what is written is not easily understood. So the example provides a great opportunity to better explain and illustrate what is said in the legislation. And it's not there as window dressing, as we now know. It does form part of the Act and should be treated as such. When you're drafting your own material, you might want to give some consideration to including an example if you believe that it would enhance the understanding and readability of the legislation. Section 14B is also very familiar to you, the use of extrinsic material in interpretation. And of course, extrinsic material can only be used in some circumstances as outlined in the Act. However, when we look at Section 14(1)(c), it's so broad that, in effect, extrinsic material can be used all the time. So extrinsic material can be used and considered if it's assisting in interpreting something that's ambiguous or obscure, if the ordinary meaning leads to a result that is manifestly absurd, or, and this is the big one, in any other case to confirm the interpretation conveyed by the ordinary meaning of the provision. So for that reason, we now see extrinsic material used very often in court proceedings and in judgments. Section 14C, this is interesting. It deals with change of drafting practice not to affect the meaning. So where we have a situation where there is the use of simplified language in new legislation, which is designed to replace previous legislation, in other words, to use a clearer or simpler style or gender-neutral language, the ideas which are contained within that new legislation should not be taken to be different merely because we use different words. And of course, as part of simplifying language, we're removing a lot of example material, we're removing a lot of superfluous material for the sake of simplicity. So we should always consider the previous meaning that was attributed to the words or words, the word or words that are being used now instead of what they were in the previous legislation. All right, let's move on to part 5. Now, when you're reading legislation, always be mindful of the headings. I like to read legislation by considering the headings from the outset. Part 5 deals with commencement of acts. These are sections 15 to 17 inclusive. Now, as indicated in your textbook, Pearson Geddes, and this is just an excellent text. Have you noticed, as an aside, how often you see a reference to the writings of Professor Pearce in particular, or this textbook, in decisions about statutory interpretation? Anyway, enough of a plug for that text, but it's very good. So at 6.4, there's a note that all interpretation acts include provisions relating to the commencement of acts, as of course I'm sure yours will when you draft it for your assessment. All use the expression an act will come into operation or something similar on a particular day, and the starting date of commencement varies in different jurisdictions, and we know that. We know that in 15A, under the Queensland legislation, an act commences on the day of assent unless otherwise expressed. Have a look at section 15B, the time of commencement, and commences at the beginning of the day. An interesting little case, which is unlikely to repeat itself often, is re Flavell, F-L-A-V-E-L-L. 1916, South Australian Law Reports at 47. A person died at 8 a.m. on the day in which estate duty legislation received assent. The assent was at about 10 a.m, but the court accepted that by a few hours, the act had retrospective effect in a reality. So the person's estate was subject to the duty, even though the person died before the assent, couple of hours. Section 17 talks about the exercise of powers between enactment and commencement. So this is all about empowering provisions, and it does deal with issues to do with conferring appointment, making statutory instruments, amending provisions, and it talks about the way in which a provision in an act that does not commence on its enactment would, had it commenced, confer those powers. Then the power may be exercised and anything done for the purpose of enabling or bringing the appointment before the enabling provision commences. Have a look at section 19, which deals with repealed or amended acts not revived on the repeal of repealing and amended acts. Again, have a look at the example. I think that's the best way to illustrate section 19. So I'll ask you to read that for yourselves, but we'll just look at the first one. So the first example is this. Act A amends Act B. A is repealed by Act C, and the amendments that were made by Act A continue to operate even though Act A has been repealed. Have a look at the second example as well. Saving of operation of repealed acts is section 20, and have a look at subsection 2. The repeal or amendment of an Act does not revive anything not in force, affect the previous operation of the Act, affect a right, privilege, or liability acquired, affect a penalty incurred in relation to the offence. Now, the key words there, I think, are in C, right, and in D, penalty. So it then goes on in subsection 4 to say, without limiting 2 and 3, the repeal does not affect the proof of anything that has happened, any rights, privileges, or liabilities, etc. So the section will preserve rights, but they must be real and not abstract. That is, some specific right acquired by an individual in which that person or people have an entitlement where others do not, and a mere hope or expectation is insufficient to create a right. So please read that for yourself and understand what I mean by the comments that I've just made, that there must be some specific right that a person or people have. The test is whether it's an entitlement where others don't have it. So section 20 of the legislation has the effect of preserving the position as it existed before the repealed Act or under the repealed Act. So bear in mind, and this is from a statutory interpretation perspective, that generally express words are necessary to take away rights that have accrued or liabilities that have been incurred under repealed legislation. So the effect of section 20 is that penalties and forfeiture under repealed law are unaffected. Legal proceedings in relation to accrued rights or liabilities are also preserved by this section. And the same applies to proceedings of a review of decisions. There's a lot of issues associated with the Mental Health Review Tribunal, for example, recently. Look, I'm just going to give you a case to look at, and I'll just explain it briefly. It's a decision of R against HXY, 2017, QSC 108. My apologies for the unauthorised citation. The defendants were charged with offences and circumstances of aggravation supplied by the Vicious Lawless Association Disestablishment Act 2013, the VLAD Act. The VLAD Act was repealed prior to the proceedings. And on a pre-trial application, the court had to consider whether Section 20 of the Act, that is the Act's Interpretation Act, applied to permit proceedings to continue and for the penalty to be imposed as though the repeal had not occurred. So do you understand the scenario? The matter came before Justice Douglas. The paragraphs that you might want to look at in short are 40 and 41. Paragraph 40 says, consequently, Section 22D of the Act's Interpretation Act preserves the potential liability of the applicants to a penalty incurred in relation to the offence arising under the Drugs Misuse Act, as well as to a penalty incurred in relation to an offence under the VLAD Act. As a result, the applications in that matter were refused. I think fairly predictably. When I read the case, I suspect that it was an application made optimistically, but not necessarily realistically. And I hope that's not offending any of the people involved in that case. Now, Part 7 of the Act deals with the functions and powers conferred by Acts, sections 23 to 29b inclusive, and these deal with statutory functions and appointments. Part 8 deals with terms and references in Acts, sections 32 to 36. We'll just highlight a few of those, so have a look at Part 8 as we proceed. The first is section 32, defined terms, other parts of speech and grammatical forms. If an act defines a word or expression, other parts of speech and grammatical forms of that word have the corresponding meaning. So if we define the word receive, of course, we don't have to define the word received. It'll have the same effect. So that's the authority for that proposition. Section 32A, definitions are to be read in context. So often we see this with statutory interpretation, the word context and the other word purpose. Definitions in or applicable to an act apply, and this is the important part, except so far as the context or subject matter otherwise indicates or requires. So when you look at this section, you might wonder how you might use it. And I'd suggest that this section might be useful if you wish to argue that the application of a definition would result in the operation of the section under consideration being in such a way that the legislature did not intend. Now, the onus of showing that a contrary intention should be applied is on the party asserting it. And the approach is to assume that the expression used as defined is correct, and then ask whether in the particular context in which it appears a contrary intention can be shown. For more detail, refer to your text, Pearson-Geddes at 6.67. In other words, always think about the general context, the general purpose, but then when you're looking at a definition, which you might think is unassailable, try to use 32A as ammunition to suggest that there is in fact a contrary definition or way of interpreting that definition that may apply in the circumstances. Have a look at 32AA. Definitions generally apply to the entire Act. Of course, there's a bit of a trick here, isn't there? Because you would have seen, I'm sure, many instances where a particular part of legislation has its own internal, if you like, definition section, so be aware of that. 32B deals with gender. So words indicating a gender include the other gender. Now, but having said that, don't be lazy with your drafting and think, well, I can just randomly put in he or she, and anyone reading the Act or interpreting the Act will have to rely on 32B. And we don't want the he, she bit either. So you need to be inventive. But let's have a look at section 32B. The application of the section will always be subject to a contrary intent. Let's look at an example, a case. Automobile Fire and General Insurance of Australia against Davies. 1936, 54 CLR 534. The court upheld a decision of an insurance company to draw a distinction based on gender. The rationale was that the insurance company could well have made a different contract if we were dealing with, say, the husband as opposed to the wife, or vice versa. And that makes perfect sense, I would have thought. But bear in mind that there's a heavy onus on anyone that asserts legislation is limited to persons of a particular gender only. 32C deals with numbers. In any act, words in the singular include the plural, words in the plural include the singular. Again, that's not a license for lazy drafting when you come to do your work. But it is a presumption only, and it can be rebutted in appropriate circumstances. So take, for example, Blue Metal Industries against Dilley, D-I-L-L-E-Y, 1969, 117 CLR 651. In the context of takeover legislation, the court rejected the claim that the singular, as in one company, included the plural, as in a group of companies. And you can see that within the context of takeover legislation, that type of distinction could be critical. Now, Are there any questions? I know that I'm talking a lot. I do hope that you're following what I'm saying, following the sections as we talk. Any questions? All right, well, I'll keep going. If there are, please stop me and ask. Let's have a look at another case. This one is from 2004. The case is C ampersand E Proprietary Limited against CMC Brisbane Proprietary Limited Administrators Appointed. 2004 QCA 60. This case dealt with a building contract or contracts. So the contract was in fact for the construction of 10 separate houses. And the question was whether it was a regulated contract under the relevant legislation at the time. In the Court of Appeal, look at the decision of McPherson JA and look at paragraphs 16, 17, 20 and 21. At 16, His Honour said, "Is this a contract for the construction of a detached dwelling?" Stating the question in that form suggests it's not. There are 10 houses, not one, to be built under the one contract. But this is to leave out of account the operation of 32C of the Acts Interpretation Act, which in a form that is familiar provides that anything that is singular includes the plural. So why then should the provisions of sections 7 and 8 of the Domestic Building Contracts Act not be read as including a contract like this to carry out the construction of a number of detached dwellings? That's a perfectly logical approach to the question. At paragraph 17, His Honour went on to say, the presumption of plurality, if it can be called that, created by section 32C, is, however, subject to section 4 of the Act, the Acts Interpretation Act, which says that the application of the Act may be displaced wholly or partly by contrary intention appearing in any Act. Actually, and section 4 enabled the presumption created to be displaced. So it's actually, section 4 of the Domestic Building Contracts Act. So at 21, His Honour said, "I can find nothing in the Act that demonstrates an intention to displace the interpretive presumption created by section 32C." And here's where there's reference to Professor Pearce. Reference to text by Professor Pearce and Mr. Bennion and other authorities suggest that provisions corresponding to section 32 have not always been enthusiastically applied by the courts. Section 32CA deals with may and must. The word may, used, generally talks about a discretion. The word must talks about a power that is required to be exercised. Again, another case. The Attorney General against Holley, Holley, 1997 to QDR 407. This was an appeal by the Attorney General. It raised two questions in relation to the construction of section 147 of the Penalties and Sentences Act. If you practice in criminal law, you'd be familiar with section 147. Now, Mr. Holley was placed on a suspended sentence. So I take it you know what a suspended sentence is. During the period of the suspension, he was charged with further offences and then he breached bail in relation to those further offences. Now, the court was dealing with the breach of bail matter and considered whether or not it had to deal with the breach of suspended sentence at that time. Section 147 of the Penalties and Sentences Act says that a court mentioned in section 146 that deals with the offender for the suspended imprisonment may, and this is pretty familiar with practitioners, extend the operational period, order the offender serve the whole of the suspended imprisonment, or order the offender serve part of the suspended imprisonment. Now, the argument in this case before the Court of Appeal was whether the court was entitled to take another alternative approach, notwithstanding the wording, by reference to and take no action at all. Defence counsel referred to section 32CA of the Acts Interpretation Act and submitted that the word may meant the court had a discretion to act under the section, or it could simply adjourn the matter and deal with it at a later time with the other substantive matters. And the argument was that it would be unjust to order the total suspended sentence be served if later it emerges the charges in relation to which he broke bail resulted in an acquittal, in which case, arguably, he should never have been charged with the offence of breach of bail at all. Possibly a thin argument, but a good argument. Anyway, the Court of Appeal said 32CA must be read in conjunction with Section 4, and in the end, it must be remembered that it would be very easy to have said must instead of may, if that's what Parliament intended. It seems to me the argument on behalf of the Attorney General does not demonstrate a sufficient reason for departing with the prima facie rule that may confers a discretion as to whether or not to make the order. Section 32D, and I know I'm moving quickly. In an act, a person generally referred to, where there's a reference to a corporation, it means individual. And 32DA talks about de facto partners. Probably less significant now with the introduction of same-sex marriage, but obviously very important part of legislation still into the future. So 32DA talks about de facto partners. Again, we'll look at a case. Spencer against Burton, 2015, QCA 104. Sharon Burton died of cancer in 2012 at the age of 56. That was in July. Oh, sorry. I'm sorry if the sound's coming through very badly. What I can do is, what I might do is just turn my camera off. I'm still here, but hopefully that might improve the bandwidth. Now, hopefully that's a little better. If it makes no difference, please let me know. So in this case of Sharon Burton, who died in July 2012, in August 2012, Kent Spencer obtained letters of administration on intestacy on the basis that he was in fact Ms. Burton's de facto partner. Now, in December 2012, Sharon Burton's mother filed an application seeking a declaration that Kent Spencer was not the spouse or the de facto, and she sought orders of letters of administration to be granted to her and that the earlier letters of administration be revoked. On appeal, the appellant argued, amongst other things, in that the judge at first instant erred by finding the appellant had not proven on the balance of probabilities that they had lived together as contemplated by Section 32DA. And in the end, the Court of Appeal actually accepted that argument on the facts. So that's an interesting case about the way in which succession law can operate in that sense. Now, when I turn the camera off, does it actually help at all? Or I'll continue to turn the camera off, but if it makes no difference, just let me know. Have a look at Section 36 of the Acts Interpretation Act, the meaning of commonly used words and expressions, and then go on to Part 9, Distance, Time and Age. We've dealt with this in statutory interpretation, the subject of statutory interpretation, so I won't go on to it too long, but just bear in mind that when you're reckoning any time, the general rule, and this is reflected in Section 38A1, is that we exclude the day when calculating and the day of the event when determining time. So again, in the Mental Health Review Tribunal, there's an obligation upon the treating team to provide the adult, the subject of the proceedings, with what's called a clinical report, and do so 7 business days before the hearing. In reality, we treat that as 9 days because we exclude the day itself and the day of the event. I hope that makes sense. Section 41, in an act, a penalty means by penalty not more than the specified penalty. So that's the maximum if it's specified. Section 42, now this is interesting. Any person may prosecute, etc. Any person may take a proceeding for the imposition or enforcement of a penalty or the making of a forfeiture order under an act. It sounds very simple and very broad. An interesting case, P against H, 2018 QDR 32, a decision of His Honour Justice Applegarth. Here's what happened in P against H. H was a police officer. During the course of his duties, he shot and killed a man, and a coronial inquest found that H reasonably believed his life was at risk because the man was pointing a replica gun. One witness denied that the deceased had anything in his hands at the time of the shooting, and the coroner found the evidence to be unreliable, inconsistent with other evidence, and found that H did in fact act in self-defence. Unsurprisingly, the Director of Public Prosecutions did not bring a prosecution against H, but by private complaint, the deceased man's father P charged H with murder, or on the alternative manslaughter. And on application by H under section 102C1 of the Justices Act, a magistrate dismissed P's complaint on the basis that it was an abusive process. Now, how can it be an abusive process when, on the face of it, section 42 says that any person may take proceedings? So P, that's the father, appealed to the Supreme Court and hence the matter before His Honour. And the appeal was to be way of hearing de novo from scratch. Justice Applegarth said, there may be a public interest in bringing a private prosecution where prosecuting authorities, the DPP in particular, have shown to be capricious, corrupt or biased in failure or refusal to prosecute, but that's not the case here. While a party may have an actual belief in the correctness of his cause, that does not make a proceeding that is hopeless any less vexatious. An abusive process may include circumstances where it can be seen that a private complaint will not be prosecuted fairly. An abusive process may include circumstances in which the private prosecution is hopeless, or at least one so lacking in prospects of securing a conviction at any trial that no prosecutor, acting in accordance with his or her duty, would persist with it. Okay, so I think that case is a very good illustration of how the apparently clear words in section 42 are subject to the overriding provisions. Have a look at section 44, Summary Proceedings. In any act, proceedings for an offence that is summary proceedings means certain things. Summary meaning essentially before a magistrate. Section 45, offence punishable only once. And note subsection 3, which says the law includes the common law. So if an act or omission of an offence occurs, the offender may be prosecuted and punished under any of the laws, but only punished, but cannot be punished more than once for the same offence. And the law includes the common law as well as statute. And we have the same sort of provision. No, we don't. We'll leave it at that. Okay, so again, thank you for your patience. That's my run through of the Acts Interpretation Act, Queensland. In the interest of time, and I'm sure your sanity, I won't go through a similar process with the Commonwealth legislation, but as we know, there's a lot of similarity between the two. I propose now to move on to the Week 8 material, which is based on Chapter 11 of your text, which is operative clauses. This is more directly relevant to your assessment regime. Before I do, are there any questions, comments, or shall I press on? We're doing okay? All right. If you're watching this or listening to this as a recorded session, please refer to chapter 11 of your text. So in topic 8, we consider provisions establishing a right, obligation, or prohibition, and we ask ourselves some questions. In the context of operative clauses, to whom do the provisions apply? When do they apply? And when do statutory powers apply? We talk about provision for criminal and civil legislation and whether offence provisions contain a mental ingredient for prosecution to prove and what alternative constructions may be possible. So in this chapter, we are very much changing our role from one who reads legislation to one where we are now considering in earnest the challenges faced by a drafter. And there are many similarities between statutory drafting and other forms of legal drafting, and of course it's relevant to your assessment. Now I should mention that we need to look at pages 425 to 439, which is chapter 11. In the study guide, it incorrectly states a reference to what the previous edition, so the actual pages for the study, 425 to 439. When you're reading the material, also consider the Office of the Parliamentary Council Commonwealth Drafting Manual. So for this week's material and next week's material, I move away from Queensland-based material to the Commonwealth, and particularly to that material, the excellent material, which is in the OPC, Office of Parliamentary Council. The primary case, unsurprisingly, Project Blue Sky against ABA, 1998 194 CLR 355. And in that case, as you recall, the High Court engaged in a careful process of interpreting a statute in light of international agreements between Australia and New Zealand. Now this week, we're talking about the operative clauses. I tend to say operative provision or operative sections, but essentially the same thing. So when we talk about the operative provisions, we're talking about the part of the statute that focuses on, if you like, correcting the mischief towards which the Act is directed. The contrast are the machinery provisions. So the operative sections, the operative provisions, are the heart of the statute. They tell people what they must do, what they may do, what they must not do. And it often contains conditions and a lot of if and unless type provisions. Now, in your study guide, there's an excellent overview of the basic models of law. You must do something. You must do something if. You must do something unless, which is a defence provision. You must do something if the condition, unless defence, and so on. So have a look at those 12 basic models. The reason that I'm emphasising this point is that when you complete your task for the assessment, you're more than likely going to have to draft something in accordance with those basic models of law. So have a good look at the way in which that's worded, and in reality it's quite simple. Now when you look at that material, you'll see that there is a subject, and that's the first thing we must consider. In an operative provision, the subject. The subject is, the subject of a sentence is the person or the thing or the concept which is performing the verb. The subject is the person who is bound by the provision. Next, let's look at duties and powers. If a court is satisfied that the purpose or the object of an act or the provision under consideration would be defeated if the task were not carried out by a person or body, it will rule the provision is obligatory and the possessor of the power has no discretion to refuse to exercise it. Have a look at Pearson Geddes at 11.3. Two cases. In Re M, 1924, 26 WALR 115, the court held that the Registrar General of Births, Deaths and Marriages was obliged to correct the register upon receipt of proof, even though the Act said the Registrar General may correct errors. And that makes sense, doesn't it? I'm not quite sure why the Parliament decided to use the word may in that context, but surely the expectation would be that the records maintained by the Registrar General be up to date and accurate. And therefore, if satisfied that a change would be necessary for the records to be up to date and accurate, rather than may correct the errors, one would think that the Registrar General must correct those errors. The second case is Disher and Disher. The statutory provision said that at the conclusion of the evidence for the complainant, the defendant may address the court, and it was held that that was permissible, that is, relative to the defendant. However, it had a dual meaning because the court, it was found to be obligatory relative to the court. So even though it said the defendant may address the court, the permissive part related to the defendant, but if the defendant chose to address the court, then the court was obliged to listen and consider the address to it. Even though it said the word may, as far as the court was concerned, it meant must. Now, discretionary powers of public officers. Problems occur when a statute provides that public officers may or may not act in certain circumstances. It might be read as meaning the public officer may refuse to consider the matter, or the public officer may refuse the matter after giving it due consideration. So do you see the distinction here? So when you're drafting your material, if you say that a public officer may or may not do certain things, the question is, do they have to at least consider the evidence, the submissions? Do they have to make an informed decision to refuse to do something, or can they out of hand simply say, no, I'm not going to even look at it. I have the power not to do it, so therefore I'm not going to. I think it's fair to say that the preferred approach is for the public officer to decide after due consideration. In other words, where there is a discretionary power conferred on a public officer, it's appropriate to expect the public officer to weigh up the advantages and disadvantages and the consequences of any decision and then make an informed and balanced decision. See West Australian Field and Game Association Inc. against Pearce, 1992, 8 WAR 64. So these provisions requiring the exercise of jurisdictional powers are generally treated as obligatory unless there's a clear intention to the contrary in the legislation. Have a look at a list of decided cases in your textbook. Refer to 11.15. The authors list examples of cases where a provision was held to be obligatory, and 11.16, where the courts have held the provisions were discretionary. Courts and tribunals. Courts and tribunals must carry out its function where designated procedure is required. Courts must consider the consequences as part of the interpretation. So again, let's look at Project Blue Sky. At 91, the court said, an act done in breach of a condition regulating the exercise of statutory power is not necessarily invalid and of no effect. It depends. It depends on whether there is a discernible legislative purpose to invalidate any act that fails to comply with conditions. Are you with me so far? Now listen carefully to this part. The existence of the purpose is ascertained by reference to the language of the statute, its subject matter and its objects, and the consequences for the parties of holding void every act done in breach of the condition. Pearson-Getty say at 11.19, if great inconvenience or injustice will follow from strict compliance with provisions, the courts are disinclined to hold that the provision imposes an obligation, and this will be so even if it's couched in mandatory terms. The authors give an example. Simpson against the Attorney General, 1955, New Zealand Law Reports at 271. The provision of New Zealand's constitution relating to the dissolution of Parliament was said not to have been complied with. The result was that strict compliance was necessary to nullify, if strict compliance was necessary, that would nullify a large number of acts of Parliament. And the court considered that notwithstanding the Constitution used the word shall, the provisions were directory only. And the result was that, that they were mandatory. If they were mandatory, it would cause extraordinary inconvenience and would have served no real purpose. So in Australia, see Clayton against Heffron. That's 1960 105 CLR for similar views in relation to compliance with constitutional provisions. You've been very patient tonight. I'm sorry that I've talked so much. So the intention is to provide, if you like, some guidance to initially the Acts Interpretation Act, and then on to parts of Chapter 11 of your textbook dealing with operative clauses. I propose to call it a night at this stage. We'll continue again next week with a further discussion about operative provisions, Chapter 11, and then we'll move on to the chapter around the week 9 material. Before I wrap up, are there any questions about what we've discussed tonight, or the assessment, or what we're looking to do into the future in this unit? Or are we all good? All good? Okay. All right. Well, thank you very much for joining me, and best of luck with your assessment pieces. I'm looking at the assessment, still only one draft submission, but you've got a couple of nights to go. All the best, and we'll see you next week. Bye then.